everybody. Hello, welcome. Welcome, everybody. Hello. Good to see you all. I'm on a little early just to give everyone time to come in and get notified. Good evening. Hello, hello, hello. Hello, Steffi. Good to see you. Ooh, it's been an interesting day today, but that's not a bad day, but interesting. Lots going on. Oh my goodness. I'm just finishing writing out my sign here. Hello, 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 Frank. Good to see you. Hello, Vicky. Welcome in. Yes, indeed, crazy. Craziness. Oh my gosh. True. We had a very interesting start here by having our New York case that was paused for the day. So very interesting. Welcome in, everyone. Again, I'm pretty early tonight, just giving everyone a chance to get their notifications. So, yep, we're just starting, Matthew. I'm just saying hi to everybody and welcoming everybody in. And I do have my squirt bottle tonight. So, no more kitten for tonight. I got to be serious. We have serious business tonight with the 14th Amendment. So, we'll have to have that. Yes, indeed, Steffi. Oh my gosh. Yes, I'm a bit early, Daisy. I thought I would give everybody a chance to get the notification. I've noticed that the notices have gone out late. I've noticed the notices. That's our world that we're in right now, everyone. So, are there any Perry Mason episodes in the future? Oh, great question. I should do that. Yeah, it's been so busy. I haven't had a chance to catch up with Perry, so I should schedule that. We'll have to do that for sure. Let me see what I can do here. Oh my gosh, that's such a fun show. Hello, welcome. Oh, you got yours. Oh, good, I'm glad to hear it, Kristen. Yeah, it was just kind of it's been kind of an interesting situation. So, yes. It's pouring rain, really, in California. Okay, and Hawk, yes. I think Hawk is going to be done with his trial here in, a couple of weeks, and so we'll see how he's doing. He's pretty busy too, so we'll see what we can do. That would be very fun though to have him back on or to join him one night. That would be really fun. He's always very fun to talk to. Great ideas. It's always fun to kind of toss ideas back and forth with people. So, yes. Oh, thank you. Yes, I've got those going for tonight. So, again, I am pretty early tonight, just giving everybody a chance to come in. But as a preview, we are going to be going through, we're going to start the 14th Amendment, Section 3, everybody. We've got so much going on with the 14th Amendment right now. It's just mania. It's mania, everybody. Oh my gosh. So we're going to start tonight, and then I will be back on Wednesday. So we're just going to kind of do a 14th Amendment Section 3 week, so we can kind of hit different issues at different nights. So how do you manage your time to get all of this? Well, just very carefully. I just have to plan. I have a lot of calendars for planning, everybody. So, yeah, I'm definitely having to do a lot of planning. Oh, thank you, Alan. Appreciate it. No, Camille, I just started. I came on a little early tonight to give everyone a chance to join before I dive into the full course meal here. So, welcome in. Welcome. Oh, thanks for the heart. Yes. Hi, Robin. Good to see you. Welcome. Do you still teach in a classroom? I don't currently, but I may again go back into classroom. We'll see how it goes. I'm desperate for the in-ground ruling. Me too. I'm also desperate for the DC Circuit ruling. I am like, come on. Where's your decision? To be impartial on this. I've got some theories, everybody, about this. I've got theories. So I see two roads in the future. We will see which road is traveled. Yes, I do teach here. I love it. Waiting on the Supreme Court rulings. Yes, yes. And they're going to have some good ones for sure, for sure. Hello, Olga. Good to see you. Yes, yes, I know it. I've been waiting. Yeah, definitely been waiting. Hi, Deborah. Good to see you. Tell us your theory. Well, my theory is just basically it has to do, and I'll set it out for you in detail. But we have case law, and so the question ultimately will be: is the case law upheld, or is the case law overturned? So that to me is going to be the big constitutional question when it comes to the 14th Amendment. So that's my big theory. So I will be going through some historical cases, everybody, and if you want to pull these cases yourself, I won't be reading through word for word. This is going to be more of a discussion style, but we've got a couple of really important cases. So I'll give you citations. You can pull those cases if you're interested. You should teach constitutional law. I did, Evan. I was able to teach constitutional law for many years, over 10 years, and that is absolutely my very favorite topic for sure. So, video with the voice reading guy from Congress Records, wonderful. Yes, very interesting, very interesting. Yes, we've got historical cases. For sure, a lot of good ones. Seen different opinions on this. Well, Navy vet, this is truly an amazing legal debate to have on the Constitution. Now, we don't have an answer. That's what we're looking for. We're looking for an answer. But I see both arguments. For myself, I have picked a side, but I'm happy to present both sides. And I feel like if my side loses, I'm okay with that too. So my heart won't be broken if my side doesn't win. Oh my gosh. Yes, and the arguments from the 1800s in Congress. Yes, it's very interesting. It's it's difficult because we've got a couple of different ways of looking at the Constitution. We have our originalists, we have constructionalists, we have pluralists, I think. So there's just a lot of different ways. The originalist way of looking at the Constitution means that we have to look and see what they originally meant when everything was passed, unless we have added an amendment to it. So that's the original view of it. The constructionist view is that it kind of grows and changes along with how our world changes. So studied employment law, yes, well, that's an important area too. Judge ruling was very good to explain. Yes, I thought they did great. And we've had a lot of really, we have 50 states plus territories. We've got a lot of very highly educated, very well-spoken people out there talking about it. So lots of different views on it. How much influence do the Federalist Papers have? Great question. So really what the Federalist Papers help us with when we're talking about the original intent, and we want to know the original intent because we're trying to figure out what the words mean. This is what it's all about. It's a language game, and we're trying to figure out what did they mean when they used this word. And so the Federalist Papers is kind of a code or a dictionary, if you will, to figure out the terminology that was used in the original 7 articles that created the Constitution and then the first 10 amendments. So we use that kind of as our Rosetta Stone, if you will. So the Federalist Papers aren't law. They're just a way for us to kind of try to decode what they meant when they wrote the words. So, and the Constitution there's lots of ways to look at it. And the third view, which is the pluralist view, which is kind of like, it keeps moving forward, but until it's moved forward, we need to rely on the original language. So it's a starting point, and then we jump off from there. So there's just different ways to look at it. And we've got 9 justices on the Supreme Court with different ideologies. And some believe in the strict construction and the strict construction according to what they believe is appropriate versus, moving forward and what it's actually meant to do. Because the question becomes, what's the purpose of the 14th Amendment, right? What's the reason why we have it? So not only do we need to look at the words that were used, but we have to look at the intent behind it. So that's where we get kind of tangled up. Yeah, the Rosetta Stone. Well, yeah. I mean, it's just a way to help us figure out what it all means. So that that's important. We gotta have some of that information. kept in there for us to some degree. We do have a written constitution. It is the oldest written constitution, and I don't know if that's a good or a bad thing, but it's just what we have to work with. So, yep. So we've got. I do have the full constitution here, everybody, and this will be our 14th. Amendment piece that we'll be going through. So I want to, before I dive too far in again, res ipsa loquitur, yes, the thing that speaks for itself, yes, it certainly does not speak for itself, unfortunately, the Constitution, but I will be going through the different pieces of Section 3, and we're going to break it down. I see it as broken down into 5 primary parts, and so we'll break each line down, and then I've got for my plan is to kind of do an overview of the 14th Amendment, the section language, and then we're going to start walking through what the language means. But then, so we've got this historical view of the 14th Amendment, but then we've also got what cases are still going. We had 2 new cases, Illinois and Massachusetts, that just filed. We had Oregon that just dismissed. We have Maine that has an administrator who has disqualified Mr. Trump. And then in Colorado, we've got a state Supreme Court that's disqualified him. So I will be going through all of the cases that have had attorneys that are not pro se. So that's really my, the group that I'm going to be focusing on. So we have the Michigan case, we have the Minnesota case. I did bring in New Hampshire because that case set out a very important test, the Baker test, when it came to political questions, which is actually in the SCOTUS brief that we're dealing with. So I will be talking about that case, but I think we'll hit the big ones, the big cases that have come out that have been filed by attorneys that are not pro se. So I will cover all of those cases and what their status is. And then I will end, again, this will be a multi-part piece, everyone. I'm not going to be able to do it all tonight. And then I will wrap it up by reviewing the Colorado case, reviewing where it's at with SCOTUS and what we can expect. So that's kind of that's my plan. That's the game plan for kind of covering the 14th Amendment this week. So, yes. Oh, I've read the Iroquois. I'm not. In fact, Benjamin Franklin took so much inspiration. I believe his articles were actually amazing. I wish we had adopted his articles. I think our country would have been, it would have gotten further quicker had that happened. Logical plan, yes. So we'll, hopefully it's logical. Yikes. So welcome in, everybody. Welcome in. I came on a little bit early tonight just so everyone can get their notifications, but welcome in. Happy to see you all here hanging out. We're going to do this week. I will be giving updates on, of course, on the Trump cases. At the moment, though, we're a little bit on pause. We've had some interesting things happen, but tonight I really want to dive into the 14th Amendment. So for tonight, construction determined, right, there's a lot going on. So for tonight, everyone, we'll start our 14th Amendment super live, and just to let you know, I will be continuing back part 2. So tonight will be part 1, and then part 2 will be on Wednesday, and then I'll probably wrap it up on Friday. So I am not going to be able to come on Tuesdays and Thursdays this week, but Monday, Wednesday, Friday, I'm planning to be here, and the focus will be on the 14th Amendment, and then of course any updates that we need out of the Trump cases. So yes, saving this live so it can be shared. Yes, so Reed, all of my lives I am able to upload onto my Tube of You channel. The only thing is that I'm not really able to edit and go through and kind of slice and dice it and clean it up. So it is an unedited version. So for a full like 2-3 hour live, it's just the full version, and I do put them up, but I stagger them quite a bit more. So I've got several that are in a queue. Their algorithm works a lot differently. So, but I do have a Tube of You channel where all of my lives eventually will all be posted. They are all saved. I just have to get them posted. So I'm just kind of like I'm a solo practitioner here. I'm just kind of uploading as best as I can as we go through this. So I'm slow, but they're coming. And I do take requests, everyone, too. If there's a particular live that you would prefer to see sooner rather than later, if there's one that you're like, oh, I really wish I could see that one again, feel free to DM me here on TikTok and say, hey, remember that live that you did about blah, blah, blah? Could you put that one up on YouTube? That helps me too, because that gives me some idea of, how to prioritize what people are really wanting. So if you've got requests, feel free to DM me and I will try to get those up too. That kind of helps. It helps me to figure out what order to put everything in, because, I'm kind of new to all of this stuff too. So that's one battery pack just went down. Let's try the next one. Oh, goodness. There we go. That's better. The impeachment trial. Okay. You stream straight to... I could. I am not that advanced yet. I am barely able to get anything posted on my TubeView. I'll be honest, everybody, all right? I'm trying. I gotta figure it out. Cop City Live a lot is crazy to see. Oh my gosh. Yeah, Suze, it really is. Oh, Estelle, thank you so much. I appreciate that. Of Biden, the impeachment of Biden. Yeah, I mean, I don't put anything on that's, I don't cover anything that I don't think is constitutional. So, unless I see an appropriate constitutional grounds for that, I won't be covering it. Yes, generous with the gifts, Kristen. So sweet. Want to learn about Section 4 as well. Yeah, so, the thing about the 14th Amendment, everybody, is it's so important. This was the turning point of the Constitution, of our whole country. And we had, of course, the 7 articles that created the Constitution. Then we had the Bill of Rights, which many call the first 8 amendments. I include 9 and 10, even though technically they're just kind of catch-alls. So... to run through a program. Yeah, I could. I'm not quite advanced enough. I need to have some more knowledge. And right now I'm just running around trying to stay on top of most of these cases because there's so much going on. But what happened then, everyone, was after the Civil War, we had 3 amendments. We call them the post-Civil War amendments or the Reconstruction amendments that were passed. And the states had to agree to ratify them in order to come back into the Union. And a lot of the states didn't want to do that. But, so just keep in mind the history that's going on here. We have the 13th Amendment, the 14th Amendment, and the 15th Amendment. Of course, the 13th Amendment abolished slavery except for as a punishment for a crime, so it still is allowable for that. But overall, slavery was abolished. And then the 14th Amendment basically set out the same kind of level of protections against the states that you had for protections against the federal government in the 5th Amendment. So the key to the 14th Amendment is that this is all about the states. So with the 14th Amendment, we had, of course, the division during the Civil War of the southern states leaving and the northern states, and we had, the Civil War. Here's the backstory. Some of the backstory is, and of course you have to remember at the time what was going on. There was a lot of talk about making slavery illegal. There had been multiple attempts for that. We'd had different Missouri Compromise, different cases that had come out, the Dred Scott case. We had all kinds of different things because this was a fundamental issue that was going on since the beginning. And it just is what it is. Those are just facts. So when everyone was trying to get this sorted out, the Republicans, they weren't called Republicans then, technically, but they were the ones that were saying, this is it. We need to make slavery illegal. This needs to be gone. We need to finish it. So a lot of these southern states got wind of it, and it was because of this fear of this federal legislation coming through that was one of the triggers that started the war. All right, it's one of many, but So keep that in mind when I do go through and we're talking about the history and we're looking through these cases. It was the Republicans that were against slavery and trying to abolish it. It was the Democrats that were pro-slavery, or you could look at it as the southern states again versus the northern states. Those ideologies and things have changed significantly, but that's how it was set. Of course, of course. And if you know anything about President Lincoln, you'll know, of course, as the country, the issue of the Civil War was slavery. And some people may say, well, it was a difference between states' rights and federal rights. And that's true, but it was states' rights versus federal rights with regards to slavery. So you can kind of, or liberals and conservatives. Right, I suppose they were a liberal party. Well, actually, one of the original parties was called, I believe, like the Freedom Party, that were completely against slavery and eventually became called the Republican Party. So yeah, it's very interesting. Or the Party of Lincoln, the original Republican Party. So what we had, again, 13th Amendment, then the 14th Amendment, 5 sections to the 14th. And then I'll just touch briefly, we do have the 15th Amendment, which just said you can't be denied the right to vote based off of race. And that, of course, was all part of the Reconstruction. So we had a lot going on there. So when we go to Section 1, this is probably one of the most well-known pieces here. All persons born or naturalized in the United States and subject to the jurisdiction therein are citizens of the United States and of the state wherein they reside. So we have a case, I believe it's the Kim Wong-Soon case. I may be wrong on the third name, but that case was decided by the U.S. Supreme Court, and they used this section of the 14th Amendment to say if you're born in the United States, you are a citizen. So that's the very first sentence here. No state shall make or enforce any laws which shall abridge the privileges or immunities of citizens in the United States. Now, this is a very important clause. We call this the Privileges and Immunities Clause. This was the number one issue that we were having, right? Where people didn't have protections against their states. The states had too much power, and that's why we had a civil war. Because the southern states said, we're going to do whatever we want to do. We don't care what the federal government says. And so then part of the 14th Amendment said there are privileges and immunities amongst the states and within the federal government that need to be respected. And because of that, we're going to put that into the 14th Amendment. So that was Kim Wong-Ark. Thank you, Josh. Okay, thank you so much. I appreciate that. I think I had said AIM, so appreciate that. All right, so Privileges and Immunities Clause. So we have the Citizenships Clause. We have the Privileges and Immunities Clause, everybody. Nor shall any state deprive any person of life, liberty, or property without due process of law. That's the Due Process Clause. Now, the Due Process Clause is also in the Fifth Amendment, but that only applied to the federal government, did not apply to the states. So now it applies to the states. At the state level, if you were charged with a state offense, you had no right to due process of law. The states could run their cases however they wanted to run it until after the Civil War. So just think about that. Their due process was not required at a state level until the 14th Amendment. All right, so that's kind of important to remember. Action info. Oh, yeah, definitely. Nor deny any person within its jurisdiction the equal protection of the laws. Now, this is something that's the new language. This was brand new, fresh, right out of the box, equal protection. So any of the times we've got questions about, race, religion, ethnicity, any of those First Amendment rights, any of our protected classes, all fall under equal protection of the laws. Now, it says any person, by the way, not any citizen. So any person within the jurisdiction of the United States is entitled to equal protection of the laws. So that was an incredibly important piece. So that's Section 1, everyone, and it's a lot. It's a lot. So Section 1 is really what we rely on heavily. We had, again, a U.S. Supreme Court case that established this jurisdiction issue if you're born here. We had another one with privileges and immunities, and I would say this one came out of a batch of cases that we refer to as the slaughterhouse cases. Slaughterhouse cases are a very famous set of cases involving what kind of rights states have versus the federal government when it comes to the 14th Amendment, and whether or not the 14th Amendment only applies to issues involving the 13th Amendment. Because right after this was ratified, everybody was like, well, it only applies if we're dealing with former indentured servitude situations. And the Supreme Court said, no, that's not true, actually. So it needs to be applicable. Bona fide citizens and natural. What does the 14th Amendment say about the bona fide citizens and naturalization in terms of privilege? So the best way to take a look at that is going to be through the case that I had cited, because this is more of a case law question than an actual language of the Constitution, because our language is too broad here. So take a look at this case here, and you will be able to see that analysis. Oh yeah, and they really go into that privileges and immunity piece of it, and also within the slaughterhouse cases. You can just look up literally the slaughterhouse cases, and it will pull up a batch of cases for you that go into that as well. So we had that, and then deprivation of life, liberty, or property, what that means in due process. We've got tons of cases on that, or equal protection, and then any of our equal protection cases, which are any of our First Amendment cases that you can think of. The Brown versus Board of Education case is here. All of those cases would fall under the Equal Protection Clause. All right, so we have all these cases, but when you think about Section 1, I want you to remember all these pieces, because as we get into the language of Section 3, eventually we're going to get down to Section 5. And Section 5 is what everyone keeps saying is so important, right? The Congress shall have the power to enforce by appropriate legislation the provisions of this article. So I want you to take a moment and think about what that means. Congress shall have the power to enforce by appropriate legislation the provisions of this article. Now, if you take that and let's apply it to this, let's do this next piece right here. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So does that mean Congress has to make a law that says that states can't violate privileges and immunities? Does the federal Congress have to pass a law making it illegal for states to violate privileges and immunities for other citizens from other states? That's the question, right? And next, nor shall any state deprive any person of life, liberty, or property without due process of law. So the question is, does Congress have to have a statute that says no state can deprive someone of due process? Where's the federal statute that requires states to use due process? Right? Right. Oh, it's okay, Deborah. We're kind of chatting back and forth. Tonight. I'm doing a little bit different format. We'll see how this runs. We'll see how this goes. But thank you so much. No, the Constitution simply outlines. Right. I guess it's a legislative body. Right. Okay. The Fifth Amendment. Sure. The Fifth Amendment does say that regards to the federal government, but not the states. So if the federal government, Congress, is the only way you have due process, if you're charged with a state charge of, let's just say theft, all right? You stole something from a local store, shoplifting. So you're charged with a state law. Now, in order for you to go through the due process, right, you get charged, you have certain rights, but you're only entitled to those rights because of due process under the 14th Amendment. So does that mean that Congress had to pass a law guaranteeing that your state would provide you due process? Right. I don't have an answer, everybody, but that's the question that we need to ask. So keep that in mind as we get through Section 3, all right? So when people are saying, this is self-executing, that's going to be one of the phrases you're going to hear a lot, that you don't need to have Congress pass a law in order for the 14th Amendment to work. That's what a lot of people are arguing about. Does Congress have to pass a law giving us equal protection? Well, we do have the Equal Rights laws, right? We do have equal rights laws. So was equal protection then triggered by Section 5 under the equal rights laws or the civil rights acts that were passed? All right, fair enough. But what about due process? What do we have to have a law written on the books in order to be entitled to due process? Or is it the fact that it's just written into the 14th Amendment enough for it to now be a right? Right. So this is the question. That's one of the big legal arguments, everyone. I don't have an answer. Again, I don't have an answer for you. But that's why we're asking this question. So let's bump up to Section 3. Let's just break this apart into a few different pieces. We'll just analyze the language and then we'll kind of start walking through what it means. The question is the level of due process. Right. Why hasn't it been done already? We didn't need it. The Constitution is kind of like, if it's not on fire, it's not going to get much attention. And so Section 3 is on fire right now. Section 4 was on fire when it came to the debt ceiling. So that got a little attention. A few people got some hoses out. But now Section 3 is on fire. Why do some amendments say Congress shall pass laws to enforce? That's a great question. It goes back to the intent and the language that was used at the time when they were fighting it out in Congress and arguing about it. Appeals court should have ruled today. I know. I'm waiting as well. I'm waiting for that. So let's pull apart the language here in the Section 3. All right. Now Section 2. I don't want to skip too much. There's a lot in here, but we need to start digging into Section 3. So here, one of the biggest pieces, of course, we have some taxing issues going on here that we needed to clean up. We have a choice of electors here. And then male inhabitants who are 21 years can vote. So really, that's kind of the big key out if you're a male inhabitant. Now, if you're not a male inhabitant, no voting for you. So too bad. Or if you're under 18, or if you're under 21. Those came later with the 19th Amendment and the 26th Amendment. Oh my goodness. States has legislation that conflict federally, so if they didn't abide, it would. So if they pass something that conflicts with the Constitution, then the Supreme Court will overrule it. Right? So that's kind of our issue that we're having right now. We're trying to figure out if that Colorado law that allowed the Colorado Supreme Court to rule the way it did was unconstitutional. And if that ruling was unconstitutional, we'll have to figure it out. All right, so here we go. So here's the first piece. No person shall be a senator or representative in Congress or elector of president and vice president. Remember, we vote for electors, not for the actual person, or hold any office, civil or military, under the United States or under any state. So that's the first clause. So this is no person shall, and that's a restriction that we're placing on something that can be done. So no person shall, and then the next part, we've got the word who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state. So we've got two pieces now. So we've got a restriction and we have some kind of act that they had previously done. So that's the second piece. And then the third piece, to support the Constitution of the United States. So that's a key. And then shall have engaged in insurrection or rebellion against the same. So we have an engagement piece. And then next we have or given aid and comfort to the enemies thereof. All right, so those are the pieces of the clause that we're taking a look at. And then, of course, we have this final piece, which is the removal of the disability. But Congress may vote by 2/3 to remove the disability. So Congress can remove it. So there is so much going on with this language that it becomes difficult to completely sort out. Now, let's just take it a piece at a time. So, no person shall be a senator or representative in Congress. So, no one in Congress. We've already got that taken care of. Or an elector of a president or vice president, right? Or hold any office. So now we have this question of, well, what do we mean by an office? What exactly does any office include then? And this is where things start getting a little bit tricky because we're not sure. So we're going to have to take a look and say, do we want to go with what they meant at the time when they were arguing about this in Congress back in 1868? Or do we want to go with what we understand an office to be today? Which definition of office are we going to use? Or are we going to use what the office meant in the original 7 Articles and 10 Amendments, or what it meant throughout the entire Constitution? That's the question. And then, or under any state who, having previously taken an oath, now there's been some question about what oath. Well, what kind of an oath do we need? Let's look at the language. An oath as a member of Congress or an officer or a member of any state legislature or executive or judicial officer of any state. So we have 2 state positions and then we have federal. So the 2 federal would be Congress or any other office of the United States, that's the federal level, or at a state level in the state legislature or the state judicial or executive officer. All right. Now, note the language here. They put in for the state part. Hopefully everyone can follow me here. I've got this hopefully bumped up enough. Can everyone read that okay? Let me get down in here a little bit further. We'll go get a little bit closer. There we go. All right. So let's just take a look. Who, having previously taken an oath as a member of Congress, so this is a federal, or as an officer, and this is a federal. And then we have as a state, or as a member of a state legislature, or as a member of the executive or judicial officer of any state. So the difference between federal and state here is, or as an officer is specified for federal, but in state it says, or as an executive or judicial officer of any state. So why did they use the language executive or judicial officer for the states, but not executive or judicial officer for the United States? Why didn't they include those 2 words up here when they were referring to the federal ones? Federal officer, right, federal officer. Yep. But why not include the executive or judicial officer language? That's the loopholes, right? I know. Because at the time, no president could have done those things. That's a good point. I think that's a good, because the section doesn't apply to the president. Maybe. They had so many loopholes. But I think they did have a lot. Insurrections and uprising. Well, right. We're not even at an insurrection yet. We haven't even hit that. We're still trying to figure this out. So, is it because an officer of the United States as a federal officer was given that included everyone? That it was so well known that there wasn't a question? That obviously the president was included as an officer because he takes the oath of office, and it's called the presidential office. So by having that, was it so commonly known that he was an officer that it didn't even bear putting into it? Meanwhile, you have all different kinds of officers in the judicial and executive branches in a state legislature. So there's all different names when it comes to state stuff. So if they wanted to say a state executive leader, they wouldn't know what to call them. Meanwhile, there's only one when it comes to the United States. All right? That's what I believe. It's common sense. Right. That's one of the theories. Everybody. Again, this is all we're just kind of talking through this. We don't have any definitive answers. All right, so 2 federals, 2 states, an officer. And of course, we have this idea of an oath. So we have an oath, and then we have this idea of an officer. And then to support the Constitution of the United States. Now, we've had some questions about that because we have 2 oaths. We have an oath in Article 2 that the president takes, and then we have an oath in Article 6 that talks about, Article 6. Let's redo that. There we go. Article 6 that talks in general about the oath of office. And actually in Article 6, actually let me just show it to you here since I have a constitution. In Article 6, it does set out specifically this language, right? The senators and representatives before mentioned and the members of several state legislatures and all executive and judicial officers, all right, all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. So some people are saying that by this language that the president is excluded because the president takes a different oath. So there is an oath that is set out that supports the Constitution, which has that same language in it, but they didn't say president, they just said officer. So let's take a look at the presidential oath. So if we look here to Article 2, okay, here's the presidential oath. It says, I do solemnly swear or affirm I will faithfully execute the office of President of the United States and will to the best of my ability preserve, protect, and defend the Constitution of the United States. So this is the presidential oath. Some people, the legal arguments go, the Article 6 oath that says support is different than the presidential oath, and therefore the president's not covered. Some say that's because the presidential oath is more strict than the Article 6 oath. The Article 6 oath just covers everybody, but the president's oath is more important, and so those words are even more specific. So that's the argument when it comes to that. So if they're saying, well, the oaths are different, true, and you can take the view that the oath to support the Constitution only covers regular officers, or you can take the position that the oath in the second article is more important and therefore more specific. So it was, again, one of those it's a given situations. Hold an office and you're the officer of that office. It seems that way. It seems that way. So that's another question, everybody. So that's one of our next legal arguments here. To support the Constitution, shall have engaged in insurrection or rebellion against the same. So that's our next line. And there's been a lot of questions about this as well, everyone. All right. What is an insurrection? What is a rebellion? And are they the same? Are they different? He broke the oath. I think so. I feel that he did. That's my opinion of the situation. But I am not a legal body. Well, not an elected legal body. So, well, I don't hate anyone. Well, that's not true. There's a group out of Germany that I hate. Anyway, so let's take a look here at this language. Insurrection can happen and a rebellion can happen. People are saying legally, when we look to the definitions, that we have a rebellion is what we had with the Civil War. An insurrection is this idea that you're trying to prevent the government from doing something. But a rebellion is when you are forcefully going forward with that task in mind to actually overturn that government. So a rebellion is more than an insurrection. An insurrection is a gathering, getting together, preventing somebody from doing their job. A rebellion is using force, going forward, and taking over the situation. Right. So these questions, are really good questions, and they're pivotal because the other question is, who defines what an insurrection and a rebellion are? Who decides? Who lists out what an insurrection is? Who puts that down? Because it's not in here. It's not in the Constitution. The definition of an insurrection is not in the Constitution. So who decides it? Whose definition do we rely on? Is my question. Right. That's a tough question, right? So let me see here if I can get one of our first pieces. SCOTUS will have to. Right. SCOTUS, dictionary from that time period. Okay, yeah, absolutely. And some people are using those. Insurrection, to stop. Right. Does the Oxford Dictionary say? Right, and exactly. And this was ratified in 1868, so it was passed by Congress in 1866, so it'd need to be the dictionary from 1866. Right. Just the Federalist Papers, perhaps. Well, let me help you out. There's a case called U.S. v. Burr. All right, this case was decided in 1807. Now, I can't read this full case because it's a lot, but if we take a look, this was delivered by Chief Justice Marshall, and it goes into treason, which is the closest that we're really going to get to kind of understanding what that original definition is. So the division of this subject, 2 points are made. First, that conformably to the Constitution of the United States, no man can be convicted of treason who was not present when the war was levied, and that if this construction be erroneous, no testimony can be received to charge one man with the overt acts of crimes until those overt acts as laid in the indictment be proven to satisfy the court. So what they're talking about here is they're saying if we're going to talk about treason and these kinds of issues going on, we're going to need some kind of action. We're going to need some kind of due process in order to figure it out. And this is where the question with Maine comes into play, everyone, because in Maine, according to Maine law, the Secretary of State in Maine can decide who's qualified and who's not qualified. And she has found he's not qualified because he violates this section of the code. And under Maine law, that's absolutely appropriate. But now the question becomes, but if we're going to claim insurrection, what level of due process is needed? Is an administrative process to determine whether or not you've engaged in an insurrection the same as the administrative process to determine whether or not you were born in the country or you've lived here long enough or you're old enough to be president? Because those seem like different standards, is what most people are saying. Most people are arguing it is a higher standard to make a determination of a criminal action than it is to make a determination of some kind of an administrative technical things such as you are 35 or older. And the due process level that's needed for that was not what was met in the Maine case. So that's the big question there. Now, in the Colorado case, it's different because in Colorado, we had a week of a whole case where evidence was put on and so forth. But then the question was, what level of evidence? We had burdens of proof. Did we have an administrative burden of proof, a civil burden of proof, or a criminal burden of proof? Well, there's no loss of freedom, so is a criminal burden of proof beyond a reasonable doubt appropriate for an administrative proceeding? But we're determining a criminal act, but for an administrative purpose, right? So the question that I would relate this to when we're thinking about this is, if the Department of Transportation decides whether or not you have your driver's license, they can determine if you are, I'll give you an example, if you, for hypothetical example, if you do not give a breath test in the field when you're pulled over, they can pull your license. You've not been convicted, you've not had a trial, you're just being charged, but you're saying, no, I don't want to blow, I don't want to do a breathalyzer. They can pull your license. That's an administrative function of the Department of Transportation. All right? So there's been no due process going through there. You can appeal, you can go through the process, but good luck with that. But now my question is this the same? Because you do not have a constitutional right to drive. Don't get me started with traveling. All right, everybody, don't get me started with that. You do not have a constitutional right to run for president. Again, controversial. So now my question is, does an administrative agency then have the right to determine the disqualification functions for an administrative question when it comes to a criminal action? It's hard. That's one of the legal arguments. I don't have an answer. We're kind of just asking these questions. Yes. Okay. Yeah. I mean, that's one of the big questions. So they're saying in Maine, why does the administrator get to determine an insurrection? And I would say, why does the DOT get to determine that you had alcohol when you didn't blow? All you said was, no, I'm not going to do a blood alcohol test. I'm not going to do that. And because of that, you've lost your license. So we didn't even have a finding of any guilt, but you still have lost a privilege. And so in here, again, we didn't have any finding of an insurrection. Now, the controversial piece of this that also comes through another case, which we will go through here in a little bit. Your license will not determine the fate of the country. Valid point. So we have another case that I will be going through here in just a little bit, and it's called the Griffin case, and I've spelled it incorrectly. And this, everybody, is the key to this whole situation, is this case. This is the key. This is the case that holds the key. It's this case. Oh my gosh. So when we go through the Griffin case, we're going to make this determination as well on who gets to who triggers everything and who is making these decisions. But a lot of people are saying, again, should an administrative secretary of state have this level of authority? Michigan said no. These kinds of questions, constitutional questions, are not to be done through administrative means. Minnesota said no. The parties determine based off of our law who's on the ballot. Our Secretary of State doesn't have that kind of authority to make those determinations. And even if you are unqualified, you can still be on the ballot. That's what Minnesota said. Oregon said, we're not going to decide this right now. Oh my gosh, New Hampshire's like, meh, get out of here. But these are the big cases, the big questions. So Michigan and Minnesota, the decisions that came out of both of those cases were very similar, saying essentially the Secretary of State doesn't have the level of authority to make this kind of a determination. All right, so that's the other huge question, insurrection or rebellion, and did that occur? Some people again would say, are we dealing again, you've got that kind of DOT scenario versus this idea of having this full kind of criminal situation or even going through that impeachment. Some people are claiming that impeachment level of due process found that he was not impeached for it. So these again are the legal questions. So the next part is one that's really triggering a lot of people, and understandably, or given aid and comfort to the enemies thereof. So this is another piece where I would have to pull in the Burr case, everyone, because when we're talking about giving aid and comfort, a lot of people are saying, well, what about for the people on Jan 6 that were arrested? That are serving prison? What about this kind of promise of pardon? What about this promise of leniency? Is that giving aid and comfort to the enemies? So you have to figure out what exactly we're talking about by an enemy of the United States, because this is actually very specific. Is this person, this entity, trying to start war against the United States? And then using the factors and the tests involved in that question to make that determination. So you would have to do that analysis with each individual person that has been arrested, that people are thinking he is, going to pardon or whatever. Was it truly their intent to start a war with the country? Was that the intent, and were they acting based off of that intent? Because if not, they do not qualify technically as an enemy thereof in a legal sense. It doesn't say war. No, it doesn't. Right. So we have to have war being levied. And that's, again, why the Burr case is so important. When we're talking about this idea of treason, when we're talking about an insurrection and a rebellion, treason against the United States shall consist only in levying war against them. So what's the natural import of the words levying war, and who may be said to levy it? Had their first application here. And you may say, well, treason's different. But for purposes of Section 3, when we're talking about an insurrection and a rebellion, when you're looking to precedent, I think it can be allowable to use the case law that we have set out. Now, again, I'm pulling these out as legal arguments, everyone. So we can all agree and disagree on all of it. But I would say if you're really wanting to take a look when it comes to what we're talking about by enemies, and I'm specifically talking about an enemy. When you are determining and defining an enemy of the United States, it's someone who is levying war against the United States. Being an enemy involves treason. So even though an insurrection is not treason, an enemy of the United States is going to involve that element of treason. Are you following me with that? So up here, we've got insurrection, but when we're talking about enemies, we're talking about treason. Is everybody with me on that? Okay, yeah. That's one of the legal arguments, everyone. So that's one of the issues that we are debating back and forth. If people were a part of January 6th, so they were at war during the insurrection, does that count? You have to really look at the intent. You have to look, what did they take? What did they prepare for? What happened before the event, during, and after the event? You're going to have to look to the totality to figure out, was anyone charged with treason? That's my question. Was anyone technically charged with treason, or were they charged with multiple other offenses? So some people may actually have hit the high bar as an enemy, but you're going to have to prove it in every single case. We can't do a blanket statement across everyone and say anyone who participated is an enemy. We can't do that because we actually have a legal definition of what an enemy is. Seditious conspiracy. Right. Seditious conspiracy. High treason is not, well, yeah. Sedition, right. Yeah, there's a lot. That was the highest. But that's the thing, everybody, is that sedition, all right, which I'm not trying to minimize anything. I'm saying for the legal arguments, when we're defining what an enemy or who an enemy is, we're going to be looking to that highest standard of who is an enemy of the United States. Treason was him. Right. It seems like it. Rebellion or insurrection. Right. Contrast with sedition and insurrection. So you're going to have to look at the legal terminology. I think I did a live a while ago going through the differences between those two. I don't have it at my fingertips at the moment, but I think it's very important. It was planned, so intent can be proven. Sure, it can be intent, but you can't have intent alone. You can take it as a piece, but to truly show that someone is attempting to commit treason, that's the level you're going to need in order to have a true enemy of the United States. It's a high bar, everybody, which is one of the things that Justice Marshall is talking about in the Burr case, is how high the bar is. The persons actually set out together and were near enough to assist in the commission of the fact. And so they go into all of the different pieces again of all of the different ways that was attempted with the Burr situation. But they go and explain, again, you have to have this high standard in order to be considered this level of treason, in order to be considered to be charged with that. So in the Aaron Burr case, we of the jury say that Aaron Burr is not proved to be guilty under this indictment by any evidence submitted to us. We therefore find him not guilty. So there was a ton of evidence. Again, if you take time to read through this case, there was a ton of evidence in this case. And in this case, if they did not find it, I'm not sure how they can take all the details of the Burr case and apply it to the people involved in January 6th. And have them be qualified as enemies under how our current precedent is written. So you'll have to take a look. I can't go through the full Burr case tonight, everybody. We just don't have time for it. So this is going to be one of the homework assignments that I would send with you. I have the Burr case. This is the citation. Take a look and read it, and then I'll give you the Griffin citation as well, and we can spend some time on that again. But tonight we're kind of doing our big start. Section 3 doesn't mention treason. It doesn't have to. By mentioning the word enemy, the word treason is behind enemy. So how do you define enemy? You can't just use a dictionary. We can't just use Black Law Dictionary. The enemy is defined by how our case law and our precedent have defined enemies of the United States. And they've defined it as a treason type situation. Yes, insurrection again, and I'm not saying there wasn't. I mean, I think there absolutely was an insurrection. They're preventing Congress from doing their job. That is the textbook definition of insurrection. But whether or not they are the people that were convicted are enemies of the United States, within this meaning, saying Mr. Trump is giving aid and comfort to them, that's the question. That's the one piece here. So a lot of people, again, are getting tangled up on this. Like he's giving aid and comfort. He's offering, whatever, blah, 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 in order to help them out. But the first question is, are they truly enemies of the state? So of the United States. That's the first question. Is treason those elements involved? And then next we would have to say, what exactly do we define as aid or comfort? Right? That can be anything. If I give somebody a cup of tea, is that comfort? So if he goes and visits them while they're in prison, is that comfort? Does that rise to the level of comfort? If they are determined to be enemies, is that comfort? And if they were true enemies of the United States, why weren't they charged with the treason code section? A pardon is comfort. Yeah, I could see that. I could absolutely see that. If he tells them he loves them, is that comfort? I mean, I'm just curious. These are the questions. The 1866, if you tell somebody you love them, is that comfort? I don't know, everybody. I don't know. Oh my gosh. Disruption of the democratic process, right? Which is the insurrection. Hard to sing. Singing is comforting. That is true. That is very true. Oh my gosh. The wording is enemy of the Constitution, not enemy of the U.S. Fair, and I think that's a fair argument. But it says, again, to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same or given aid and comfort to the enemies thereof. So again, the enemies of the United States or the enemies of the Constitution, I think could be interchangeable, as opposed to where earlier we're talking about taking an oath to the Constitution, because we have oaths in the Constitution. Meanwhile, enemies of the United States would be anyone who was an enemy of the Constitution. See what I'm saying there? Paying legal fees is comfort. Ah, that's funny. So these are the questions, everybody, though. I mean, that's a great point. I think that's a great argument. And we may even hear some of these. He didn't call the National Guard to protect the Capitol. So we have his behavior before, during, and after. And if you look at his behavior before, a lot of people would say that would be his engagement, was because he asked everyone to come to the Capitol, come to Washington, D.C. That was the engagement part. So that was before. And then during, he's talking about, all of these reasons why blah, 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 blah. And then after, by not doing anything, does that mean that by his omissions, that he's agreeing with the insurrection? That's a little bit of a stretch. But by not doing anything, is he aiding, again, enemies? Well, we don't know if they're enemies or not. That's not been determined. He did request in advance. That whole story about the National Guard and what was requested is up for debate. What's not up for debate is when he did not make any calls during the time of the actual invasion. So when the breaking in was occurring, there were no phone calls made by him. So that's what I'm doing, calling them hostages. Well, I mean, you can call them, Boston cream pies. You can call them whatever you want. But legally, can they be called enemies? That I don't know. He said, I'll walk with you. True. And perhaps he would have. Would that have been comfort? I don't know. Maybe. Can Trump still legally run for president? Well, yes, for right now. Yes, he can legally still run for president right now, everybody. Absolutely. Yep. Insurrection charges be given to someone that's an enemy, or does it need to be more? That's a great question. That's a really great question, I think. We have to ask that. Yeah, it was, Nikki Haley, right? She screwed up. I don't know. He said he loved them, yes. And with our vernacular in this moment, we would see words like that as comfort. But when they're writing this out, comfort in, 1866 is like, here, do you want to take my goat? So you can have something. That's not going down the right road, everybody. Here's a bushel of apples. That would be comfort. Okay. Oh my goodness. In 1866, they don't use words of love. That's madness in 1866. We're giving out bushels of apples. Oh my gosh. And then again, that's only applicable to enemies of the United States. Get them out of jail would be offering aid. Well, that's the question. That's really that question. And even if you're just making a promise to someone, is that actual aid? Or is it when you actually fulfill that promise? So by just saying, I will give you a pardon, is that something that's punishable? Or do we have to wait until the pardon actually happens? Because there's a pretty big difference. Because he promised a lot of people a lot of pardons. And a lot of people did not get a lot of pardons. So by just saying the word, I will pardon you, is that comforting enough? Or does it have to be the act itself? Removing barriers, perhaps. It actually happens. It's giving comfort, if nothing else. Fair enough. That is an offering. Okay. So, that would comfort me if I was in jail. I think so. Oh my goodness. I agree. Aid is, he pardoned Roger Stone, who's tied. Right, he did. But he also didn't pardon him for other things. And he seemed quite upset about that. Define enemy. Exactly. We have to do that. If I offered something in return for you voting, is that legal? Offer a pardon prior to committing a crime, is that different? That's a good question, but I'm not sure it's still at that same level. So I guess I would even go basics down to contract law. Let's go, do we have a contract? If the president says to you, if you go and invade the Capitol, I will pardon you. Is that a contract? Is that a legally binding contract? Well, first of all, no, because it involves an illegal act. So you can't have an illegal act be in a contract. So we're not dealing with a contract situation. So if we're not in a contract world, what world are we in? Are we in a conspiracy world? Yes. So we do have some conspiracy questions. But now, do we have a conspiracy that includes pardoning as a comfort for an enemy? I know, right? I know. Oh my gosh. I know. It's going to go round and round and round, everybody, round and round. But important pieces, again, all of these have arguments on all the different sides. And then here's the last sentence. Here we go. But Congress may vote of 2/3 of each house to remove such disability. Now, I think there's something really important here. We're in crazy town. I know. Oh my gosh. So may vote to do the 2/3. Okay. So one thing that I would point out to everyone here, all right, this means Congress can pass an act or something in order to do away with the disqualification, all right? And I'll get into this in a little bit here, but just to give you an example, we have the 1870 Enforcement Act, and it says here, an act to enforce the right of citizens of the United States to vote in the several states of the Union, be it enacted here of the United States. And then we go down to the 14th Amendment right here, Section 14. And it be further enacted here, that whomever any person shall hold office, except as a member of Congress or of some state legislature, contrary to the provisions of the 3rd section of the 14th article of the amendment to the Constitution of the United States, it shall be the duty of the district attorney of the United States for the district in which such person shall hold office, as aforesaid, to proceed against such person by writ of quo warranto, returnable to the circuit or district court of the United States in such district, and to prosecute the same to the removal of such person from office. So we do have an act that was passed talking about the enforcement of the Section 3 here of the amendment. So we have that. But let's take a look again. Congress may by vote remove the disability. This then, the implication is that the disability automatically attaches. All right, so follow me here. How are we removing a disability if Congress hasn't already written legislation to enforce the Section 3? Are you following me on that one too? That one's a little bit of a stretch. That's a little bit of a stretch. So Congress may vote by 2/3 of each house to remove the disability, meaning if any of these apply, it's automatically self-executing. And the only action Congress can do is to remove the disability. They don't act to put into place the disqualification because it's automatic. They have to act to remove the disability. All right, you following me on that one? That's another big piece. That's a huge, huge legal argument right there. Take away the liability of the crime. Exactly. So the language of Section 3 itself, when people are saying, well, again, Congress has to enact something in order to be disqualified. We can't have Maine over here with their law or Colorado with their law. Congress has to set up a law stating you're no longer qualified because there was an insurrection. If we do that, then this language doesn't work, because Congress may, by a vote of 2/3 of each house, remove such disability, saying that there is already a disability without prior congressional action. George Conway? Okay, well, good for him. I'll have to take a peek at him. So that's the other huge, big legal question, everybody. If Congress can remove by vote, it means it's in existence. Exactly, Sunlight. That's exactly right. It means it's already there. It's already in place, just like as soon as we had due process of law at a state level when the 14th Amendment was passed, so too did if you were part of an insurrection and you had sworn an oath, you became disqualified. Now here, Congress can't remove it, but here Congress can remove the disqualification. But either way, congressional action is not required under the specific language of the 14th Amendment. Yep. It wasn't self-executing, then why have the last sentence? Why have Section 5 or why have this sentence? Exactly. Yeah. So this is, again, what gets us starting to get tangled up again then is that we have to take a look at our case law. So if we have case law that would set out for us, is Section 3 self-executing, meaning once it was written, it's now enforced, or does Congress need to write something? If we had case law that told us one way or the other, it would be a lot easier. Right. So then that takes us, everybody, to one of my least favorite cases. So that leads us up to the door of the Griffin case. So let's take a moment, step back from that question. So that's the question, though, that we're asking everybody. Is it self-executing? Does Congress need to act? Does Congress need to pass something? So Congress has previously passed the Engagement Act to say whatever, how it's going to be used. But now let's take a look at some case law. So this is the May term of 1869. The timing of this is incredibly important for the Griffin case because we have this passed by Congress in 1866 and is ratified in 1868. And this people and everybody arguing in this case are there in the thick of it at the time that it's happening. Section 5, Congress permission to restrict the definition of insurrection or limited scope. It's possible, but if you look to the US Code, which was written by Congress, they have already defined it. So if we wanted to actually change the definition of insurrection or rebellion, we would have to add a constitutional amendment. Yep. Because we already have the criminal language. If we want the constitutional language, we look to case law, which is what we'll start to kind of go through here, or we add it to the Constitution. That's the only way to do it. Glitching. Oh no, am I glitching, everybody? Oh no. Here, let me bump this back out a little bit. Am I back? Are we better now? Oh dear. Okay. Some Congress can't even spell. True. Already enacted section. Yeah, okay, not too bad. All right. Excellent. Insurrectionists are in Congress. Great question. All right, I'm okay. Thanks, Deborah. I appreciate that. All right, well, let's dive into Griffin's case just a little bit, everybody. This will be your second case if you're interested, because again, this is going to be part of a series of lives that I'm going to do. I cannot cover all of this. It's just too much to cover all in one live. But I will be back on Wednesday, and we're going to kind of rip apart a lot more of this language. But this is the second case. So the first case that I would recommend everybody pull and read is the U.S. v. Burr case here. This is the case number, and it's a very old case. So we have our old case citation process here. This is the most interesting college course I've ever taken. Oh, thanks, Linda. That's so fun. Oh, thanks. Now, here's the Griffin case, everybody. All right. So when you pull this up, this is the case number up here. So it's 5818, and this is the citation. And you can absolutely, oh, thanks, Estelle. You can pull this case yourself. Now, it's a difficult read. It's a difficult read because there's a lot going on in here. And they just don't write in a way that's easy to understand. But I will take you through these first bullet points that they have here, and then we'll really dig into the case later. This was 1869, so it was just right after it had passed. But again, when you're reading through this and you're looking through this, keep in mind everybody was there in the moment when this was going on. So here's number one. So first we've got recognition of state government, 14th Amendments, Virginia, government of after end of Civil War, ex post facto laws. So we have a criminal situation where there was a judge that made a ruling, and it was the ruling was contested because the judge had been involved in the Confederacy. And so his ability to actually be a judge was being questioned. So that's what this case comes down to. Here's the first. The government established at Wheeling, Virginia, soon after the secession of the state of Virginia, having been recognized by the executive and legislative departments of the national government as the lawful government of Virginia. This recognition is conclusive upon the judicial departure. This government was in contemplation of law, the government of the whole state of Virginia, though excluded as government of the United States itself from the greater portion of the territory of the state. A construction which must necessarily occasion great public and private mischief must never be preferred to a construction that will occasion neither in so great degree, unless the terms of the instrument absolutely require such preference. The prohibitory provisions of the 14th Amendment to the Constitution of the United States did not instantly, on the day of its promulgation, vacate all offices held by persons within the category of prohibition, and make all official acts performed by them since that day null and void. This is the key right here. All right, here's the key. So they're holding, in this case, the Supreme Court dude is saying just because the 14th Amendment was passed did not automatically mean that it was now up and running. So this is what the court is saying when they're saying that it is not self-executing. It's not. Congress needs to be involved in it. So let's see. Ratification of the 14th Amendment to the Constitution was officially promulgated by the Secretary of State in 1868. Persons in office by lawful appointment or election before the promulgation of this amendment were not removed therefrom by the direct and immediate effect of the prohibition to hold office contained in the third section. So this is the second piece. Again, these are the bullet points that are explained further in the case. I'm giving you kind of the highlights here. Legislation by Congress was necessary to give effect to the prohibition by providing for such removal. This is the key. This will be the U.S. Supreme Court's case. Does the Griffin case, is the precedent set out in the Griffin case to be upheld or overturned? That's the legal question with these 14th Amendment cases, everybody. Because according to Griffin, Congress has to give an effect, has to pass law in order for the prohibition to take place, according to case law. Now, according to the language, it seems as though it's self-executing. It seems like as soon as it was promulgated, it was in charge. That was it. But we have a case. And the key then is, was this case decided properly? Was the legal analysis proper? Was the ruling proper? Because if it wasn't, much like Plessy versus Ferguson, if it was wrong, if it was unconstitutional, it can be overturned. And if it's overturned, then that means this is self-executing and we can go forward. Right. So that's the legal question that's presented, everyone. Yes. So it's complicated. Rosa red, violets blue. Oh, no, the moderators. I went with the judge. I know. Good question. Good question. Oh, that's a great question too, Jostick. So with that, everyone, I had planned this out to just give you that broad overview for tonight. But I will be coming back on Wednesday, no doubt about it. So let me just kind of add here. So Wednesday, I will be back. We will pick up where we left off here. We will cover the Burr case. After everyone's had a chance to look at it, we will also cover the Griffin case, and it will be very condensed. So I'll just be pulling out the major pieces out of both of those cases. We'll cover those cases and this idea of whether or not Congress has to be involved. And then we will need to move on to our next piece. All right? I never had a life give me homework. Jimmy, it's up to you. It's up to you if you want to do it or not. Yes, 7 o'clock is 7 o'clock Central, and I'm going to be trying to come on a few minutes early so that those notifications get out. That's so funny. Extra credit. Yeah, well, it's up to you. I will explain them in a very condensed, simplified version, but if you really want to know what I'm talking about, it helps to read them. It really does. So we'll cover these two cases, everyone. We'll really, kind of tear into that. But this then will kick us into the arguments that take us through the Minnesota case and the Michigan case. Not only that, but we're going to bring in New Hampshire as well, because we need to talk about the Baker case. So you don't need to read that, but we've got the 6-part Baker's test that we'll go over. Oh my goodness. Can you make it posted with our homework assignment? Yes. Okay, so here's the Burr case. Let me do it like this. Let me give you the citations. I mean, you guys, you certainly don't have to. You certainly don't have to. All right. So, yes, could the judge run for re-election after the 14th was passed and in effect? Well, that's one of the questions, is could he be put back on the bench again? And they're saying here that Congress needed to remove him first before in order for that Section 3 of the 14th Amendment to apply to him, or else he was validly on the bench. So he was never taken from the bench, is what they're saying in this case. So hopefully I've got these bumped up. I know that the sometimes, let me see if I can block this a little bit so you can see that. All right. It's not homework, extra credit. It's up to you. It's do with it what you will, but I will be going over these if you want to know what I'm talking about. I didn't think I could just crack open these cases and walk you through them. We've got 1869 case here and then 1807. And again, 1807 is going to help you with that piece of aid and comfort for the enemies. So we'll go through the Burr case. This is that case here. And then we'll go through the Griffin case here. We'll get the history out of the way. And then once that foundation's built, then we can start going forward. Yes. Have an issue with bias or not rule in a certain way. There's a lot going on in the Griffin case, everybody. There's a lot. You have to keep in mind, I think one of the biggest issues is the defendant here was, of course, a freed person. And so what level is involved in that? So what kind of history is taking place with the actual trial itself because of the race of the person who's the defendant? And does that make a difference on whether or not the judge should have been allowed to remain in his position? We've got a lot of things going on with that. A lot of things. So there's a lot of layers. We'll go through that. Yeah, there's a lot of layers. So if we want to focus on precedent, this is the case. So if Justice Thomas wants to uphold the Griffin case, there you have it. But if this case is no longer good law and it needs to be overturned, much like the Plessy case or any of our other cases that have been overturned, I use Plessy as a quick, easy example, then perhaps that's what will happen here. The race of the, well, I think it does. I think it does, Violet. I think it matters. Give me the Cliff Note version. I'll do Cliff Notes on Wednesday. But it is helpful, I think, for someone. I have to remind myself that Burr wasn't. No, I know. It has to be Congress, or it could be the acts by individual states. According to the Griffin case, Congress has to do it. Oh, thanks, John. Congress has to pass something in order to trigger it, according to this case. But the legal scholars that are arguing the 14th Amendment are saying the Griffin case was decided incorrectly. And we have had a lot of cases that are decided incorrectly. And if the U.S. Supreme Court agrees and it's overturned, then it's self-executing. And if it's self-executing, then we start going through a different analysis. I want the Panther paw. Oh my gosh. Yes, I have, Kristen. I've made some. Yes, thank you all for coming. Yes, thank you very much. Oh, it's been so much fun. And again, we got to kind of take this in small bites because it is really complicated. It's a lot. So I don't want anyone to have, oh my gosh, to overdo it all at once. So I will be back again tomorrow or on Wednesday, everybody, and we will finish up with the history, and then I will start going into specifically the Minnesota case, the Michigan case, and the New Hampshire cases. So we're only dealing with a handful of 14th Amendment cases, but we'll start with these and finishing up the history, and then I'll finish out this series of lives with the last of the cases that have been filed, what the status is of them, which is everything's on hold right now, and then the Colorado case, which will set us up for the Supreme Court arguments. So that will be our structure, everyone. That's the plan. So with that, I will go ahead and take my leave for tonight. Again, thank you everyone for coming and joining me. Oh my gosh, it's so much fun talking about the Constitution. I can get my dork going. It's a lot of fun. So have a wonderful night, everybody. Thank you all for being here. I appreciate it. And I will be back again on Wednesday. So, oh my gosh, Estelle, thank you so much. Thank you. All right. I will be doing some posts pretty soon. So take care, everybody, and we'll see you on Wednesday.